Hello everyone, welcome back. In our previous class, we saw that for an agreement to become a contract, certain conditions must be satisfied. So we had clearly seen that not all agreements are contracts, correct? And only those agreements are contracts which fulfill the conditions that we had briefly discussed in the last class, okay? So we can say that only those agreements which fulfill certain conditions become contracts. All right? Or in other words, you can say that agreement plus certain conditions, when these are fulfilled, then we have a contract. And if these conditions are not fulfilled, then we don't have a contract. All right? So this is the first thing that we have clearly understood so far. And we are going to discuss all these conditions. Okay? Today, our focus would be to look at the first condition. First condition is competency of parties. All right? It simply means that the parties who are entering into an agreement, they must be competent to enter into that agreement. All right? So it says parties should be competent to enter into the agreement. Now we all know that there are two parties in an agreement, correct? One is an offerer and the other is an offeree. Now, as per this first condition, we understand that both the offerer and the offeree need to be competent to enter into the agreement. Okay? Now, what is the meaning of competency? We saw that both offerer and offeree need to be competent to enter into the agreement. But to understand that, we will need to comprehend the meaning of competency. What does competency mean? Law says competency means three things. Number one, party should not be a minor, which means that the party should not be below 18 years old. There's an act in India, there's a legislation in India which is known as Indian Majority Act. You don't need to go into the details of it, but just understand that there is a statutory framework or legislation which defines the term major or minor. All right? And for your understanding, don't go into the definition and all, just understand that anybody who is below 18 years of age is a minor, okay? And anybody who is 18 years or above is a major. Indian Contract Act says that if a party to an agreement, which means that either the offerer or the offeree, if any of these parties is a minor, okay, then that party is not a competent party. All right, which means that in competency, we know that number one, minor is not a competent party. All right, so we've looked at the first element of competency. Second, party should not be of unsound mind. What is the meaning of unsound mind? We will discuss unsound mind in detail, but for now, just understand this. Let's say somebody has consumed alcohol the entire night. Okay. Now, if this person has been consuming alcohol the entire night, how will his mental condition be? What do you think logically? How would his mental condition be? We know that anybody who consumes alcohol, what does alcohol do to your mind? All of us know that if alcohol is consumed in an excess quantity, then your mind stops functioning properly. You will not be able to understand what is happening around you. So that can be an example of when the mind becomes unsound. If somebody has consumed alcohol to an excessive extent, then the mind of that person becomes unsound, or it may become unsound if that person is not able to understand what is happening around him or with him. Another example of unsound mind could be somebody, let's say, who is mentally ill to such an extent. Don't get confused between legal insanity and and insanity in medical terms. Okay, when we discuss this unsound mind concept in detail, and when we cover criminal laws also, you will see that the meaning of unsoundness or insanity in law is different from how the medical science has defined it. We will not go into the details of that today, but just understand that unsoundness, first thing that should come to your mind is somebody has consumed a lot of alcohol such that that person is not able to understand what is happening around him, which means that he is not in his senses. Okay. Second, people who are mentally ill, but not everybody who is mentally ill. Somebody who is mentally ill to such an extent that those people are not able to understand what is happening with them or around them. For example, let's say somebody who is in a mental asylum and that person is not capable of understanding anything. If you ask that person to enter into an agreement, the question that you will need to ask yourself is, can this person even understand this agreement? Can the person understand the contents of the agreement and the consequences of signing that agreement? If the answer is no, then that person is unsound. All right. So we will discuss this. For now, two things keep in your mind. Let's say intoxication, and not every intoxication, every kind of intoxication which is of such a degree that the person is not able to understand anything. Okay. Second, people who are, and please don't get confused while you're making notes. I have told you that you can mention these two for your easier understanding, but it is not as simple. As I told you, not every intoxication is an example of unsound mind. Okay, so we will discuss these two in detail, but for now you just note these two aspects. Okay, which means that first we saw minor is not a competent party. Second, we know that persons of unsound mind are not competent for the purpose of entering into an agreement. Third example, any party who has been prohibited by law from entering into an agreement. Now, it may happen that the government or the law of the country itself may prescribe that certain categories of people should not be allowed to enter into an agreement. Now, if I were to ask you, all of us know Vijay Mallya, okay? Vijay Mallya fled the country after taking a huge amount of loan. He became a willful defaulter, which basically means that he did not pay back the loan despite having the capability to do so. Okay, he had the means and the resources to pay back the loan, but still he fled intentionally just to avoid repayment of the loan. Now, do you think Vijay Mallya should be allowed to enter into any commercial agreement? For example, let's say he wants to take another loan. What is a loan? Loan is also an agreement. Now, logically speaking, should Vijay Mallya be allowed to take another loan? The answer would be no, because he is a willful defaulter. Okay, so the government may pass any act or legislation saying that people who are willful defaulters should not be allowed to enter into loan agreements. Now that is what we are talking about. That if the government or the law of the country itself says that certain categories of people cannot enter into agreements or certain types of agreements, then those people are not competent to enter into the agreement. Understood? Another example you can think of is, let's take the example of Ajmal Kasab. Okay, the person who bombed, who was behind the Taj incident, Taj Bombay Hotel incident, Ajmal Kasab. Okay, would the government of India allow Ajmal Kasab to enter into an agreement? The answer would most likely be no. All right, so that is in the third category. So people who are prohibited by the law of the country from entering into an agreement. So all these three categories, minor, persons of unsound mind, and people who are prohibited by the law of the country from entering into an agreement, all these people are incompetent parties. So we can say that all these people are incompetent. Incompetent for the purpose of what? For the purpose of entering into an agreement. All right. And today, our focus would be to understand the first incompetent party. So first incompetent party is a minor. Now I told you that anybody who is a minor, which means below 18 years of age, all right, anybody who is a minor is an incompetent party, which means that a minor cannot enter into an agreement, right? If he is incompetent, we can clearly deduce or conclude that minor cannot enter into an agreement. Correct? And we had seen in the last class also, when I was giving you an example of a laptop, that there was a minor involved. Okay, so minor cannot enter into an agreement, and the law says that an agreement entered into with a minor is void ab initio. What is the meaning of void ab initio? Let's not get confused and don't get afraid of these terms. It simply means that an agreement, if you enter into an agreement with a minor, that agreement does not exist. Okay, because a minor is not a competent party. Just imagine this: if somebody is not even competent to enter into an agreement, has that agreement even been formed? The answer is no. Since a minor is an incompetent party, a minor cannot even form an agreement. All right, and therefore that agreement is void ab initio. It means that it is not enforceable from the beginning itself. Or in other words, imagine that the contract did not even exist. Even if you enter into an agreement with a minor, the law will treat it as if the agreement never existed. All right, let's understand this with the help of an example. On one side we have Rahul, other side we have Aman. Rahul is 24 years old. Okay, Aman is 16. Aman wants to buy Rahul's smartphone. Okay, Aman wants to purchase Rahul's smartphone for rupees 15,000. And Rahul also agrees to sell. Okay, they shake hands. So money is promised, phone is promised. We have an offer, we have an acceptance, and we have consideration. Okay, Rahul promises to sell the phone. Aman promises to pay the money. Everything looks proper, correct? We have an agreement, offer, acceptance, and consideration. But after 2 days, Rahul refuses to sell. Rahul refuses to sell the phone. Aman gets angry and says, Rahul, you promised me that you will sell your phone to me. We had an agreement. Okay? And therefore, if you don't sell your phone to me, I will take you to court. Rahul still refuses to sell the phone. And therefore, Aman goes to the court. Question is, can Aman force Rahul in court to sell the phone? Okay, the answer is a clear no. Why? Because Aman is an incompetent party. And why is he incompetent? It's very simple. You can answer in comments. Because he is a minor. Aman is 16 years old. And anybody who is below 18 is a minor. Therefore, Aman is a minor. Aman is not competent to enter into an agreement. And I told you that an agreement entered into with a minor is void ab initio. It is as if the agreement never existed. So even if Rahul and Aman agreed, even if Rahul and Aman exchanged consideration or promised to exchange consideration, there is no agreement at all. The law does not treat this as an agreement. And therefore, Aman cannot force Rahul to sell the phone. Okay? So we can write this again. Agreement is void ab initio. So void simply means unenforceable. And what is the meaning of unenforceable? It means that court cannot enforce, which means that even if you take the agreement to the court, court will not be able to enforce it. Now, think of the NLSIU bribe example. When NLSIU, you could not clear CLAT and then you decided to offer rupees 10 lakhs as bribe to NLSIU. And initially, NLSIU agrees to give you a seat, but later they refuse and you file a case against them. Question, will the court force NLSIU to give you a seat? The answer is no. Why? Because the money that you were supposed to pay to NLSIU is a bribe. And bribery is an illegal activity. And therefore, the court will not enforce your agreement with NLSIU. And hence your agreement is unenforceable, which means court will not enforce. Therefore, void ab initio. Void means unenforceable. Ab initio means from the beginning. What is the difference between void and void ab initio? Again, think of the NLSIU and your example. In that example, you had an offer, you had acceptance, and you had consideration as well. Is that agreement also void ab initio? Is it void from the beginning? The answer is yes, because the consideration there is illegal. Okay. Similarly, agreement with a minor is also void ab initio. It is void from the beginning. For now, just note down this thing, that there is a difference between void ab initio and void. And we will discuss this in detail. I don't want to confuse you at this moment, and therefore I want you to just mention it separately in your notebook. We are going to discuss the difference between void ab initio and void later. For now, just understand that agreement with a minor is void ab initio, unenforceable from the beginning. It is as if that agreement never existed. Okay? There's one important exception though. What is the exception? Law allows certain agreements for the minor's necessities. Now imagine this. First ask yourself a question. Why is an agreement with a minor void ab initio? Why do you think law considers minors as incompetent? Okay. Why does the law treat minors as incompetent as far as an agreement is concerned? Incompetent. If you think, you would come to the conclusion that the law does so because minors lack experience and they can be cheated. Why? Because they have not fully formed their mental capabilities to understand the contents of an agreement and its consequences. If you do an agreement with a 15-year-old boy, that 15-year-old boy, in all likelihood, what the law deems is that the 15-year-old boy is not capable of understanding what that agreement is about. Neither the contents of the agreement nor the consequences. What will happen once the agreement is signed. Therefore, the law protects minors. It's not that this is a prohibition to cause any disadvantage to the minors. The law treats minors as incompetent because the law wants to protect them so that minors cannot be cheated. All right? But there could be certain scenarios. Let's say there are so many refugees, okay, and so many poor people, and they who are below 18, and they may require food, clothing, education, etc. So law, let's say if law puts a blanket ban saying that a minor cannot enter into an agreement ever. Okay, imagine a situation of a person called A. Okay, now A is an orphan. All right. But A has some properties. A has a house. A has some properties in his village. All right. But A does not have the money, and A is a 16-year-old boy. A's parents die in an accident, and therefore A becomes an orphan. Now there's nobody to take care of A, and A wants to go to a college. A wants to go to NLSIU. What we just discussed a while ago was that an agreement with a minor is void ab initio. Would NLSIU enter into an agreement with A? The answer is no, because NLSIU would know that an agreement with a minor is void ab initio, and therefore NLSIU will not enter into an agreement with A. So how will A study? Wherever A goes, that college will tell A that sorry, we can't enter into an agreement with you because you're a minor. Imagine what will happen to A. How will he study? Therefore, the law says that for necessities of minors, agreements could be done. What it means is that if there is an agreement with a minor which involves certain necessities for the benefit of the minor, then that agreement is valid. Okay, so let's say if an agreement with a minor involves certain necessities for the benefit of the minor, then such an agreement is enforceable. All right. Now, what does it mean? It simply means that whenever you come across an agreement with a minor, just look at two things. Number one, let's say A is offerer, B is offeree. All right. And B is a minor. So you have to verify two things to decide whether an agreement with a minor is enforceable or it is void ab initio. First, check whether one of the parties is a minor. Okay, don't immediately come to the conclusion that just because a minor is involved, the agreement is void ab initio. Never do that. First step is to check whether, step 1, check whether any of the parties is a minor. If the answer is yes, if yes, then proceed to step 2. Check whether the agreement deals with any necessity for the benefit of the minor. If the answer is yes, the agreement deals with a necessity, then the agreement is enforceable, which means that the agreement is valid. If no, if the agreement with the minor does not deal with any necessity for the benefit of the minor, then the agreement is void ab initio. All right. And I gave you one example of the orphan who wants to study at a college. Studying is a necessity. Okay. So you can understand this. What are the necessities of life? Food, clothing, education, health. All right. These are necessities of life. But suppose somebody enters into an agreement with a minor for selling an iPhone. Is iPhone a necessity? The answer is no. iPhone is not a necessity. All right. Therefore, that agreement will be void ab initio. So just think of necessity as the bare minimum things or the reasonable things that are required for the minor to live a reasonable or a standard quality of life. All right. That will be a necessity for the minor, for the benefit of the minor. All right. Now, for the first category, we saw that agreement is enforceable. Does it mean that minor will have to pay from his pocket? Does it mean that minor is personally responsible or personally liable? Let's say NLSIU example, the college gives admission to the orphan and the college knows that the agreement is enforceable because it is for the benefit, it is for a necessity which is for the benefit of the minor, for the orphan. All right. So they give admission to the orphan. What if the orphan refuses to pay the fee later? Will the orphan be held personally liable? In this scenario, when the agreement is enforceable due to necessity, even though the agreement is enforceable, minor is not personally liable. Then you would ask a question. Then why would anybody want to enter into an agreement with a minor, even for necessity, when the minor is not even liable for breach? The answer is, even though minor is not personally liable, but minor's property or estate will be used for payment. All right. It simply means that even if the orphan, who is a minor in our case, even if that orphan has 1 lakh rupees in his pocket, NLSIU will not be able to force him to pay 1 lakh rupees. But I told you that the orphan had a few properties in his village. The orphan had a house. So NLSIU will be able to use those properties. All right. Saying that the orphan owes rupees 5 lakhs to NLSIU, and therefore orphan's properties or assets will be used to pay off the fees. That is the crucial distinction that you need to remember, that if a minor is involved and an agreement is for his necessity, then minor is not personally liable to pay. Okay, no court will say that minor should be personally liable. The court will only order that if the minor has any property or assets, then those properties or assets will be used for the payment of the money owed to the other party. All right. So this is all that you need to keep in mind as far as minors are concerned. So this concludes our discussion on the first incompetent party, which is a minor. Tomorrow we are going to look at the second incompetent party, which is person with an unsound mind. All right. If you have any questions, please feel free to ask. I would love to respond to your questions. All right. And please study wisely and study smartly.